I'd like to take this opportunity to thank Stikeman Elliott for being on ACC 2020 sponsor and for providing us with this program today. Continued support for the ACC from Stikeman Elliott and others allows the ACC Alberta to continue providing relevant and timely programming. ACC is the largest in-house network in the world with over 45,000 members in 85 countries. In Alberta, we have a healthy chapter of over 1,300 members who are in-house practitioners. Please come join us at accalberta.com for upcoming programming and networking events, as well as to check out the abundance of online resources that are available for in-house lawyers working both in Canada and internationally. And watch for more information about our upcoming Alberta Annual Fall Conference. And with that, I'd also like to welcome here today and say good morning and potentially good afternoon to our friends from Saskatchewan and British Columbia. We welcome you today, and we also welcome you to our online fall conference or in person, as some of you have attended in the past. Thank you very much for joining us, and I'm going to turn it over to Stikes.
Hey, thanks very much, Chelsea. Good morning, everybody. My name is Mike Nastynczyk. I'm a partner and head of the advocacy group here in the Calgary office. I appreciate the kind words that Chelsea has expressed, and I will say that we're very excited to be able to do this with you today. I find these to be very interesting and educational, not only for people who attend, but also the presenters. So thanks very much for that. We've got a great panel set up for you today that I will moderate. It includes, as you know, Chelsea, who is lead counsel to the Canadian Industrial Operations at PCL Construction. So she is with us. And it's always great to have people like Chelsea with us at these because they give us that valuable real world in-house perspective to some of the issues that we're discussing as external counsel today. And joining me in doing a lot of the heavy lifting in relation to discussion as well are two of our great young associates at Stikeman Elliott. The first, Janelle Young, a senior associate in our corporate commercial group with a practice focusing on general corporate matters and mergers and acquisitions. And with us as well is senior associate Sarah Graham, who works with me in the advocacy team and has a broad practice focusing primarily on commercial litigation and regulatory matters. So they will be assisting with the substantive content today, and we will continue as we go through the presentation to monitor for questions that may come up in the chat box. And as those questions come up, folks, we'll do our best to address them as we go through. A couple housekeeping matters. If you just note that your mic will be muted as for all of these types of webinars, so you're not going to be able to participate orally as an audience members, but there is a chat box at the bottom of your screen. If you touch that or click on that, you'll be able to post questions that we can then filter into my chat box that I can then relay to the panel. So without further ado, I'd like to talk about the topic we're going to discuss today, which is alternative dispute resolution. And, I will say this, in the COVID world, ADR has gained some additional importance, and primarily it's because of the realities of our courts in Saskatchewan, BC, Alberta, and all the provinces of Canada. As many of you know, the courts have been essentially shut down for several months. They are just reopening now to hear non-urgent matters. And as we know, commercial matters are often shunted to the bottom of the list when it comes to urgency in favor of criminal matters and family matters. So ADR, I think, is a timely topic for a situation like COVID because it, I think, has heightened importance when you look at the need to have a swift dispute resolution in a state where the courts just aren't available. So we're going to talk about it today. We're going to talk about 5 different things, 4 main topics, and then a wrap up in Q&A. We're going to talk about the question of whether you choose litigation or alternative dispute resolution, which we are all of the view on this panel is a very important one when you're deciding how to deal with disputes that arise in your commercial relations. Number 2 is choosing a dispute resolution mechanism. So once you've decided that you're perhaps going to do ADR, what kind would that look like? Number 3, we'll spend some time, and probably the bulk of the time today, I expect, talking about factors. So the various factors that you might want to consider when you're deciding what kind of dispute resolution mechanism you want to choose for your agreement or your relationship. And then 4th, some drafting considerations that will touch on some real world issues with respect to how to draft these clauses and how to use them, and at the same time perhaps relating them back to drafting factors to consider as well in topic 3. So that's what we're going to cover, and without any further delay, let's talk about the question of litigation or ADR, And I will ask Sarah Graham to lead us off on this topic in terms of her views and observations on how you make this critical choice and what the issues are.
Yeah, thanks, Mike. So I guess this is the preliminary question that everyone needs to think about. Obviously, litigation is something that people are more familiar with. It is the default dispute resolution mechanism in Alberta. However, while some contractual dispute resolutions are drafted with the absolute goal of avoiding the traditional litigation system, others choose to include litigation in the overall dispute resolution process, either as a strategy of last resort or to determine discrete issues. So we have here on our slide that perhaps a more appropriate acronym would be appropriate dispute resolution, in that appropriate dispute resolution is about the advanced consideration of the dispute resolution mechanisms, obviously determining in advance what the right mechanism is for your resolution of your disputes, and ensuring that the contract provides for this recourse. So the point that we really want to emphasize today is that drafters need to consider how they wish to have disputes resolved when entering into contracts. So, perhaps an apt analogy is ADR provisions are the prenups of commercial contracts. Everyone always goes into a contract with the best intentions, hopefully, and hoping that nothing will go wrong. And no one really wants to consider that things may go wrong and things may fall apart. And I think what's important is to anticipate that down the road something may fall apart, and you want to be sure to have the best protections possible in your contract. And as Mike said, this is especially important today. No one contemplated that courts would basically be inaccessible to commercial disputes for the past 3.5 months, and even getting back to business after June, it's going to be delay after delay as commercial or criminal matters and family matters are prioritized over commercial matters. So, in this day and age, potentially more than ever, you want to consider alternative dispute resolution mechanisms in your contracts to ensure that you're not held up by the court system's backlogs.
Yeah, I agree, Sarah. Those are good comments. And Chelsea, from the perspective of the in-house counsel at the purely commercial level, what are your observations on at least that initial question, litigation or ADR?
Well, I think that Sarah's walked through a really good point there about the courts being closed. And one thing I want to talk about is this question of litigation or ADR and the temporal question that goes with it. Like, when do you make that choice? Janelle is going to walk us through some of the things that we might consider for our contract, because you can make the decision going into the contract about what you're going to do, but you always have the choice, if both parties are willing, to consider a different form of dispute resolution. Both mediations and arbitrations have continued while the courts have been closed. And I think in some circumstances, the parties have agreed to an ADR in these last exceptional 3 months because they can get that access to justice. So certainly it's something we want to think about going forward. But just because you don't have a provision in your contract today doesn't mean that you can't opt to take something on. Certainly arbitration can be more efficient. Like, for example, today, when you can't get into court, there's other factors we're going to talk about. But I think that it's a question worth always asking, both when you're forming your contract, how do we want to resolve this dispute? And then down the road to say, how could we get out of this faster at this point? Things like mediation are always available, whatever your contract says, if you can both agree to do so.
Yeah, thanks, Chelsea. And maybe we could just put the next slide up, then the choosing a dispute resolution mechanism slide. Go one further, and maybe we'll get Janelle Young to weigh in on this regarding the various types of clauses that are an option for you as a drafter or a deal maker when the commercial relationship is starting out or ongoing. And what are your observations on that?
Like you said, when you're deciding what the most appropriate dispute resolution mechanism is, you need to know what your options are. So typically when you're looking at drafting an agreement and you're making this decision at the outset, you're really making a decision between litigation or arbitration. It's certainly possible, and we often see parties include negotiation or mediation as part of that. But those are really just mechanisms to try to help the parties come to an agreement between themselves, either by getting them in a room together, giving them a third party to help them walk it through. They're really more effective as a precursor to something like arbitration rather than a standalone ADR mechanism. We do also sometimes see parties agree to really quite bespoke provisions where they will refer certain discrete types of issues to a technical expert of some kind or some other expert. And, you can see them agree that the intention is that the determination of that expert should be binding on them. As Sarah mentioned, sometimes the parties don't spend all that much time thinking about what the dispute resolution mechanism ought to be. They either, go within their view, rightly or wrongly, is, the typical approach for that type of transaction, or what they've done in the past, or what they're comfortable with, which may or may not be the right approach now, especially in light of backlogs, increasing backlogs in the court system. And, we're really obviously trying to encourage parties today to spend a little bit more time thinking about that deeply. So I think, the overarching comment here on how do you choose is that there's no really one size fits all. There's a number of factors for each of the parties to consider, and we'll get into those in quite a bit of detail in just a minute. But they're also not all going to point in the same direction. Different parties may have different options, may have different preferences. And so I think what it really comes down to is for each party to sit down, decide what they think is best for them after weighing the pros and cons, and then negotiate with the other side to come to an agreement for what's going to be included in the agreement.
Yeah, thanks, Janelle. So, Chelsea, tell us about your experience, or at least give us some observations about your experience when you're making this choice, including, I think, a topic that is of interest, and that is the prevalence, right, of ADR versus litigation. I know that right now your career is focused on that construction sphere, and we know that there's a certain way that things are done in that industry, absolutely. But, that or beyond that, what have your observations been?
I think a few comments. I mean, one, it's not necessarily that you're picking one thing to go with. And Janelle talked about the stepped resolution mechanisms, and I think that that's really important and quite common. Then what you're identifying is that there is a dispute between the parties and elevating it at each time. So sometimes that can be 3 or 4, depending on the corporate structure, 3 or 4 steps up internally with different levels trying to weigh in. And one thing that offers you is new people and new feedback and new perspective. And it also allows times for the parties to consider how right they might be on what they're saying and to uncover more evidence. And also it gives them time to consider how important the particular dispute is. In addition, sometimes when 2 people are having a dispute, it can go personal. Whereas if you raise it up within the organization, you can look to remove that element of personal conflict from the dispute itself. So that's one thing. In addition, I think that it's not necessary that you're picking one. You might decide that arbitration will be your path versus litigation, but that you're going to have a mediation attempt, or you're going to have an all-executive meeting, or you're going to have any other means along the way to get there. So it can have a variety of complexities to it, and certainly a lot of the contracts that I see and process in this field do. And partly that's the bespoke nature of the industry, as well as the sophisticated projects and contracts that come into play, and the desire to resolve disputes as opposed to ending up in litigation. That's never a win. I tend to like to have arbitration set out there, or the stepped process set up there, and then if necessary to mediate through it. I think that mediation has a tremendous amount of value, but you can use the arbitration as the way to set out the facts and for each party to be able to clearly delineate exactly what their case is. There are places that prescribe mandatory mediation. Some jurisdictions have it as part of the rules of court. Some of the human rights tribunals have mandatory mediation, and I know we have some friends from one of the tribunals with us today, so welcome. Feel free to ask questions or provide comments on that. And I know that they say that it's very successful despite the fact that it's mandatory. In other circumstances, sometimes it's not as successful if the parties are too embroiled in their own issues to want to work through them. A lot of times I think we have to think about what it means to have a successful mediation. Sometimes you walk away and you feel like, well, it didn't resolve, so it wasn't a success. But what you don't see is that you actually moved a lot closer together and you flushed out what the issues actually are. And so even if it doesn't resolve on that day, it can often resolve in the near vicinity to that discussion. I would add a note of caution with respect to adding in the idea of experts into your dispute resolution provisions. And what I would say with that comment is the expert going to be binding or not? Because if it's not binding, what is the value? And is it without prejudice or not? If you have an expert, who owns that expert report? Who's entitled to use it? What is the value of it? Who's paying for it? There's a lot of questions that come into play there. And it's not that it's not a great resolution mechanism. It might be, but you want to make sure that you're making the path clearer, not potentially adding more obstacles in your way. So those are some of my comments, Mike.
Yeah, I think those are good ones. I mean, I would echo your comment about, we call it in our business moving the goalposts, right? I mean, there's lots of ways to move the goalposts together. Mediation is a great one. Stepped resolution mechanisms are very effective, and you're right. You know, first you don't succeed, try again, right? Sometimes it takes multiple rounds of these types of efforts to get to where you need to get. Let's talk a little bit now, folks, about the factors, because I think, oh, sorry, Chelsea, I think you had something to add there.
Oh, sure. No, I was just going to throw out that I think that sometimes there's this feeling of needing to have their day in court, that everybody wants to have their day in court. And to lawyers, that has a distinct meaning when we say in court. But for a lot of other parties, it just means to be heard. And I think that whatever line of business you're in, whether you're in-house, whether you're dealing with individual people or companies, that's a really important thing, to be heard. And that day in court can actually be a day in front of a mediator or a day in front of the other side. I've conducted mediation successfully without a mediator, but just to listen and sort of have that airing of grievances.
Yeah, makes perfect sense. Let's talk a little bit now, because it's a good segue, I think, about the factors, everyone. And these, of course, we've touched on these a bit already in the first few minutes, but let's look at them in some more detail, because a lot of really interesting points in discussion come out of simply looking at the factors. And so if you go to the next slide, you'll see the first part of the list of factors that you may want to consider when you're making decisions about whether to use litigation or ADR, and if you're going to use ADR, what kind of ADR are you going to use? And that's on this slide and the following slide. And I'm going to ask Chelsea to start us off here, just in the sense of some global thoughts about the factors before we delve into some of them in more detail.
Sure, absolutely. Thank you. One of the things that I think when you're talking about the factors to consider is, how do you broach this idea with your commercial group or with the group that's signing the contract? And certainly, there can be a feeling when you're starting to talk about the disputes that you don't really understand the plan, because the plan is to have a successful project, or the plan is a successful sale. And as lawyers, we often have to be that dark cloud that floats in and says, but what if things don't go according to plan? So one of the things that I'll sometimes do with my group is I'll say, so what would be like the worst thing that could happen? Or what kind of disputes could arise? And sometimes I'll throw out something really ridiculous that would never happen, and then we'll all laugh and agree that would never happen. Or sometimes something really inconsequential. Or I'll throw something out and then walk it through how that wouldn't be such a problem. But it's just to get that conversation going, because I don't know the operations of my group anywhere near as well as they do. And I certainly don't know all the technical things that could go wrong. But I think it's really important to canvas this as a conversation and say, look, part of it is, if we have these small disputes that arise, what is the most efficient way that we could resolve them so that they don't get blown up into something that's way, way worse? And then, as opposed to acknowledging, a small problem, it becomes, the old analogy about turning a molehill into a mountain. So that's the kind of conversation that I like to have at the beginning. And sometimes when there's a long there can be even more resistance to that policy. But I think that in some respects, that's when it's even more important to consider, because you want to make sure you can preserve that business relationship. And disputes do arise. I think that in Canada in general, we do a pretty good job of not making a litigation, a cost of doing business, the way that they do in some other places, but they can arise, and it's just a conversation about how you're gonna resolve them. So a lot of the ones that we have up on this screen are things for them to consider. They might not already have considered this. For example, talking about a highly technical expert, to them that might not be a highly technical person, and they might think that everybody understands widgets and flanges and hills and arcs and channels, and those might be things that are subject to a very particular skill set.
Yeah, makes perfect sense. And let's start with this, Sarah. Why don't you pick a few from these two slides, or one, or however many you think come to your mind as being particularly interesting, and give us your thoughts on these factors and how they weigh on the decision-making process for commercial folks.
Yeah, thanks, Mike. Yeah, as Chelsea kind of alluded to, one of the factors that sticks out to me is whether the dispute is going to be highly technical or require an expert adjudicator. I think one of the most difficult jobs as a litigator when you get into court is trying to educate the judge. You're working with very sophisticated commercial parties, and they have been in their industry for a lifetime, and then you get in front of a judge who was a criminal prosecutor for their entire practice and have been sitting for 6 months, and having to try to explain to them liquid natural gases or delay claims in construction files. It can be very time intensive and very difficult, and you're kind of just crossing your fingers and hoping for the best that you explained it to them. I think that's a huge advantage for choosing arbitration, is you get to pick your arbitrators, and you can pick people that have been in the industry and understand what is common, what is normal, what's not normal. So I think that's a huge factor. Another factor, I think, is if one of the parties is a foreign national. Obviously, our courts in Calgary don't reach to the Ukraine. So, arbitration can be a huge advantage if you pick an arbitral body that has been recognized in that jurisdiction. And we're not only looking at whether a party is a foreign national, but where are the meaningful assets? A judgment is only as good as whether you can enforce it. And it's not a great victory to your client if you win, but you can't seek any enforcement of the judgment, and you're kind of left with nothing. And the final one I would point to, I think it's on the next slide, is whether confidentiality or precedents are important to your client. A lot of clients are very nervous about sharing their state secrets of their company, and they get nervous that the court process is a public process. Anyone can come watch your trial. Documents that are filed in court are public unless you can file them confidentially, which, there is a certain, standard to get that done. So it's not all that common. So I think, if confidentiality is really important to you, you want to opt maybe for arbitration. But on the other hand, if precedent might be important to you, for example, if you think that this dispute may arise again and again in a certain jurisdiction, especially, you may want to go to court and get that precedent set so that, when you're coming out of it, you have a decision you can show the other party and say, you're not going to win this fight. So that may be valuable to you.
Yeah, those are great points. It reminds me of, the case we did years ago. And this speaks to your first point about, the technical nature and expertise. I recall it was a drilling case, and it was going to be a 2 or 3 week trial, I think, with lots of experts, and it was pretty technical because it involved details about the actual drilling process. And one of the first questions that came from the trial judge when we were doing our opening statements was, and this is no disrespect to the trial judge, they had the background they have, but the question was, what is a frac? And I remember counsel looking at one another at that point, and we realized we had to downshift a lot in terms of our expectations about what we would need to do in terms of educating the judge about what those key factual parameters were for the dispute. So I think those are great points. Janelle, what about you? Did you have any of these that you felt were of a particular note?
Sure, thanks, Mike. I'd like to touch on two that are maybe less legalistic or technical than some of the others, but they're ones that I have spent a fair amount of time talking through with business folks on files when we're talking about ADR clauses. And those are the significance of the disputes or the potential disputes to the parties, as well as the relative bargaining power between them. These often go hand in hand a little bit, but in terms of significance of the dispute, if it's really a kind of bet the company type of situation, things would be catastrophic if there was a breakdown in the agreement. Sometimes you see parties quite reluctant, I guess, to give up some of the procedural protections of litigation, especially in a situation where you might otherwise be agreeing to binding arbitration that has no rights of appeal. They can be really reluctant to give up those rights of appeal. Conversely, if the disputes are maybe not going to be all that material or important in the grand scheme of things, there can be more of a desire to take the cheap and cheerful approach and go with the relatively more cost-effective and quicker arbitration route, or even that could be a situation where one of the other dispute resolution mechanisms like mediation might be effective. And then in terms of relative bargaining power, this is where you really see parties sit back and consider what tactical advantage they might have or be able to bring or glean from a particular approach. So I recall one deal where the counterparty inserted an arbitration provision, and the response from the business folks on our side was, a healthy dose of suspicion about why they were including it, what they thought that they were getting from it, and kind of how it was going to be a disadvantage to our client. And some of that is a completely reasonable thought. So I've heard sometimes the view that the party, the underdog, or the party with less leverage might want or might like to look to gain some leverage from litigation through the ability to kind of name and shame and make the wrongdoings of the other party public. But I guess in my experience, I most often see that those parties with less leverage are also the ones that are less equipped to deal with the cost and time impositions of litigation. So often they're very keen to do arbitration. So in that case, a party with relatively more bargaining power might think that they gain a tactical advantage from litigation. And of course, one size fits all. But those are often considerations I see.
Yeah, thanks, Janelle. Chelsea, what are your thoughts on these factors, and which ones jump out to you in your experience as being important when you're making these decisions?
Well, all of them. And it's always, depending on the particular circumstances of the case. But, one of the things that I would bring up is that we talk about relationships between the parties. And sometimes we think about that in terms of this company and this company have done a lot of work together over the years and they have a solid relationship. But organizations are just, groups of people that are involved in the organization. They're run by people and governed by people. And when you think about it, when you look at things like cross-examination, you're going to be cross-examining those individual people. And in the in-house context, that's generally speaking, you're going to be cross-examining those people with respect to the things that they did in their employment and in their profession. And those are really sensitive things for a lot of people. We mostly like to show up and do a good job and try our best. And then to have them in and cross-examine, as we're hired to do, can have some really negative long-term consequences. And I think that needs to be really considered when you're talking about a party with which you have a lot of goodwill. Sometimes as lawyers, we think of it as one big chessboard and moving the pieces around, but those pieces are people, and we need to be a bit careful with what we're doing there. Another factor is you'll often think about, not airing dirty laundry in public. I think that's a huge thing for a lot of companies. It's pretty much guaranteed that a reporter will pick up whatever's been filed and maybe get it right. And then, if you're unlucky enough to get into the news, and I don't have a lot of experience with this, the way that the news works these days, each story builds off the story before. So that can definitely have a really negative consequence, particularly to companies that are publicly traded. And then another comment to consider is if you're in litigation, every time you're in litigation, it creates a public record. And we all know that. But think about getting into new bargains, and you can look up the party that you're considering entering into a contract with and see how much litigation they've had and done. And it creates it creates a history, and maybe you want that history to show that you're really tough and you will enforce all your rights and defend yourself. But it does create an opportunity for other people to look at how you have treated your previous business relationships.
All very good points, and I pick up on that theme. You, as litigators, certainly, it's easy to spell out what you can do. Okay, so a good litigator will tell you what you can do. All right, in my experience, the great ones are the ones that tell you what you can do, and they give you really good advice on what you should do, because simply exercising all the rights that you can exercise without a strategic thought to an overall business or commercial relationship is not doing the most service to your clients. You want to make, ultimately we are part of a team working to make sure your business works well, right? And I think the really good lawyers that I've run into over the years understand that, and they're always thinking about that, right? When they're dealing only with direct clients without in-house counsel, but I think even most importantly with in-house counsel teams, and a lot of people on the ACC call here today, that's where you are. We are a team working to service the same client, right? And we have different roles and responsibilities in terms of checking those boxes, but those are great comments. I'd add a couple to the factors without going on for too long that just occurred to me. One is the question of the sophistication of arbitration. So, back in the early 90s to mid 90s, when the Alberta Arbitration Act was amended to make it a lot harder to get out of arbitration if you had agreed to be in it, arbitration was not as sophisticated. The systems weren't set up for it. And frankly, a lot of people weren't trained for it. It's very different now in 2020. There are private law firms in Calgary that have their own private courtrooms that they built in their offices to handle sophisticated arbitrations. The software, the technology to host and handle large complex files is a lot better. So while it used to be a bit of a negative to arbitration if you had a really big and complex dispute, that's, I don't think, really the case anymore. The modern arbitrations, I think, are every bit as efficient and capable as the courts, and frankly, in a lot of ways, a lot more when you look at some of the drawbacks or the delays in getting our modern courts modern in the context of electronic filing and electronic data. The other thing I would say is this, when you think about arbitration, one of the most important things to remember is when you're looking at the type of dispute, you realize and you understand that your arbitration agreement only binds the people who have signed it, right? So if you're, and I'll use the construction world, Chelsea, as an example, because in construction, often when there's a litigation, if you walked by the construction site at some point in the last 5 years, you get named. Like that's a running joke amongst us litigators. Everyone gets named in these construction files. Yeah, everyone gets it. But in almost every case, not all of the people who are responding to an alleged defect or problem are signed up to an arbitration. You can't force them to arbitrate, right? So those arbitration clauses are really good when the type of dispute that you're going to be in is likely to be a one-on-one dispute, right? Contractual interpretation, something that really just involves and engages the two parties. If you're in a scenario where you've got multiple parties who may have a hand or may be responsible in a negligence type scenario, it gets a lot more difficult, and that quite often you're stuck in litigation in that scenario because of that. Those are all important factors to consider.
A factor as well that if you're going to pick arbitration, you want to, as far as possible, have everybody that's going to be under the same net be subject to the same arbitration. So, in the construction example, which I can speak to, if we agree to arbitration with the owner, we want to make sure that all of the other players, all the other contractors or subcontractors or suppliers or designers, whoever else might be a part of that project, insofar as possible, is subject to the same arbitration provisions, and that we're all going down the same road together, that we've all opted out, because you're absolutely right. It's a mess if you're half in and half out. I don't have any experience with that, but I can imagine it would be extremely difficult. Having said that, I did have one case a few years ago where, there were about 10 different parties involved in my part of the litigation. And because of the nature of it, the parties were not all subject to the same arbitration. It involved a tremendous number of insurers. And So there were, like I say, the 12 parties, and there were side agreements, and some of the ensuring contracts provided for arbitration, and some of them provided for litigation, and some of them provided for other mechanisms. And it was one time that I used mediation really successfully, and basically said to all of them, we are all going to get in, I can't even pretend it was a room we wouldn't have fit, but we're all going to get in one building together in Vancouver on these 2 days, and we are going to mediate this, and we're going to bring in mediators. And it was hugely successful. And I think part of it was all the parties were sophisticated enough to understand what this looked like down the road. Now, we were also able to use some other temporal factors to our advantage. I mentioned it was an insurance dispute, so we were able to look at things like bad faith and whatnot to create more of a time requirement for everybody to do that. But I think that's one of those ways when I was saying I like to set up the facts and the evidence, and then mediate through it. It was a really tough week. And I also alluded to sometimes you'll set up your mediation and it'll feel like it's unsuccessful. We worked really hard those 2 days, and we left there and there was no resolution. And then, Wednesday and Thursday were extremely difficult days, but we did ultimately reach resolution with all the parties that week. And I think that was just such a much better alternative than, I can't even, my mind is just lost at the possibility of how much time would have spent in courtrooms if we'd had to individually do all of that.
Yeah, good points. So let's do that. Let's leap ahead then a bit now that we maybe canvassed some of those factors and look at some of the drafting considerations, because I do want to spend a little bit of time with the group this morning talking about that in terms of actual pen to paper work. And so when we get into the drafting considerations, and we just head into the slide right next to that one, which is the other choice, we start thinking about when you're putting pen to paper, what kind of ADR do I want to use, institutional or ad hoc? And I just would ask Sarah to give some brief comments for us on that question.
Yeah, thanks. So yeah, one of the first things you may want to consider when you're drafting your clauses is whether you want to go the institutional ADR or the ad hoc route. So when you're choosing an institutional ADR, it's going to be administered by an institutional body and their procedural rules. So this could be the National Arbitration Rules of the ADR Institute of Canada or the ICC in the international context. And those are generally adopted. These institutions provide support and supervision of the process, and you're subject to their rules. The other option is to choose more of the ad hoc approach, which, that provides more flexibility. You're choosing your procedure more as the dispute arises. So that can be potentially advantageous because, you might want to tailor the process to the actual dispute. And in the ad hoc world, you can obviously adopt and incorporate the procedural rules from elsewhere, whether it's the Arbitration Act of Alberta or rules of an arbitration institute or UNCTRL, whatever would suit the dispute. So that's one of the first drafting considerations you may want to consider.
Yeah, and those are good points. Chelsea, have you had experience in your decision making and thoughts on institutional versus ad hoc from the commercial level?
Sure, absolutely. I'm familiar with UNCTRL. I've agreed to LCIA. These are just different frameworks for arbitration. In general, I tend to think that it's better to set out one at the outset. And the reason being, if you put in an institutional arbitration system, you can always negotiate to have a more ad hoc system with the other party if both parties agree that would be better. But if you don't have it in there, then in a time where you're already in a lot of disputes, you're saying, well, that's the time that we will agree about how we will resolve the disputes that we're already having. So generally speaking, I would think it's not super great to think that you're going to be able to agree on one thing when you are already fighting about so many. Whereas if you have the institutional already set up, it kind of presents you one step ahead, and then at least you know the forum that you'll be resolving under. And I think that if the parties think that they will negotiate into a better process when they're in the middle of a dispute, it's a little bit naive, because obviously the other party is going to want to do the same thing. And the only way that you're going to reach a conclusion if it truly is a better match for the dispute itself. And then that comes back to my comment, just because you pick the institutional doesn't mean that both parties can't agree to amend it or to provide a bit of ad hoc to it. In general, we've got this simple ad hoc wording up here. And sometimes I'll hear parties say, or they'll, with the negotiations that go back and forth, there'll be kind of a split the baby type thing. And they'll say, oh, well, it's better than nothing. And I'll say to them, are you sure? I'm not always sure that is better than nothing, because at least with nothing, you're set up with your litigation rules of court. Whereas if you say you're going to arbitrate, but you don't have your provision, you could certainly be headed off to battle about what the arbitration is meant to be. In general, there's 3 things that I think that need to be set out, and I'm happy to talk about them now, or actually I could wait, Mike, and talk about them after we go through the separate clauses. Maybe that would be better.
Yeah, let's do that. Because I think you talked about that simple ad hoc clause, and I think the one you're talking about is the next slide after institutional or ad hoc. If we could just ensure that's up on the screen for the group. And this is what we have identified as a simple lacking clause, one that is extremely thin. But maybe I'll ask Janelle to take us through this, and then Chelsea, as you see fit, just weigh in.
Yeah, so like Mike said, we've identified this one as lacking. I mean, it can be really tempting to go really simple with something like this. I guess the positives of this clause are, it does make clear that the choice of arbitration is what the parties have decided on. It makes it clear what the scope of the arbitration decision is, so it applies to any disputes. But where it really fails is, like Chelsea was saying, if you're including an arbitration clause, your goal is to avoid court. So don't leave ambiguity or unresolved issues around what procedure would apply that are just going to find you in court fighting over whether the provision ought to apply in the first place or how it ought to apply. So the things in my mind that are missing from this is there's no real procedure set out for how a party would go about instigating the arbitration. You'll typically see a provision that either party can refer the dispute to arbitration, and there's a certain time frame within which they have to do that. That's missing here. You're also missing the forum, as Chelsea mentioned, which is really important. And if applicable, how you're choosing your arbitrators, what your language is, etc. And so I guess that brings me to another kind of overarching point when you're looking at drafting an interpretation of these dispute resolution clauses, is that courts really like to give effect to ADR provisions. They will interpret them broadly and try to make them enforceable. And if this clause was in Alberta, we'd have a little bit of help in the form of the Arbitration Act, which would step in, and to the extent that the parties either failed to provide for something or when the dispute arises weren't able to come to agreement, it would step in to fill some of those gaps. But again, the problem is that it may or may not do that in the way that the parties would have preferred or envisioned. So if to the extent that you can just set those out at the outset, and we'll see when we get into a couple of the other provisions, it doesn't involve a whole bunch more words. It doesn't involve a 2-page long provision, or at least it doesn't need to. So it's a lot better to just do that right at the outset.
Yeah, and before we go on to that next clause, I'll ask Sarah to point out for us, there's a great quote. Some of you may have seen it before. It's from the Kappa Energy case. It was Justice Cote, when he was still on the Court of Appeal, had that great quote in that case, and we'd love to share that with you, because I think it captures the points that Chelsea and Janelle have just made really well.
Yeah, Justice Cote, always good for the zingers, but his quote was, "Arbitration only after a lawsuit about arbitration is likely to be slower and more expensive than the lawsuit which the parties contracted not to have." And I think that summarizes it so well. Like, you don't want to be in court fighting over how you're going to arbitrate. That's the least preferred outcome of an arbitration clause.
If that exact scenario happens, for my in-house colleagues, if you're in court fighting about the dispute resolution mechanism that you're going to employ, I expect that our internal clients are going to say, "Are you kidding me?" And I think that that's not going to be a great moment for the legal department.
No, I
Thank you.
totally
Sorry,
agree
Mike.
with that. And Chelsea, I've seen that, right? I mean, it is extremely difficult when you're looking for quick resolution of a dispute, especially in an ongoing commercial matter. And cost is everything, especially these days. Your legal dollar to resolve disputes is a limited dollar in this day and age, and you want to be as efficient as you can. So let's look at that next clause then, because we touched on an example of something that isn't too long, but certainly gets a lot of other things out of the way and gets a lot of other things right compared to that lacking one. And I'll ask Janelle to lead us through this one.
Sure, yeah. So this is the model clause for the ADR Institute of Canada, and generally where the parties have chosen institutional arbitration versus ad hoc, it's really beneficial to just take a look at the model clause that institution has put out there. They're really easy to find, and they're tailored to the rules. So that's really beneficial, and that's exactly what this is. It hits on some of the major points that were deficient in the lacking example. It sets out that the ADR Institute of Canada rules will apply, says where you're going to host the arbitration. If applicable, it can say the language. So infinitely better and not that much longer.
Right. And if we, just because I know from a timing perspective, we're running close to noon, let's just go right over now, Janelle, and let's talk about the simple ad hoc, which is also in our materials one slide later. And I guess we could observe here that in this example, even though it's an ad hoc arbitration, there's still some things that are set out here that will, in large part, at least try to keep you out of court.
Yeah, exactly. And so, I mean, there's a couple things that I really like about this provision. The first is that kind of middle sentence that says either party can demand for arbitration by filing a demand in writing within a set number of days. That just provides a lot of certainty to the parties about how they ought to go about triggering that provision. And then the second thing is just that last sentence where it sets out really clearly that the determination of the arbitrator is going to be final and binding, and that there are no rights of appeal. So that is also helpful in terms of framing the parties' intentions. Other than that, it doesn't go too far into the procedure, because that can be one of the concerns with ad hoc arbitrate, is if you kind of try to set out all your rules up front, it may or may not be the right fit, and then you could lose some of the flexibility that you were hoping to have with the ad hoc. So, it does say that the Arbitration Act of Alberta will apply, so that's helpful. And otherwise, it preserves some of that flexibility.
And Chelsea, any comments on this one from the commercial side?
Yeah, absolutely. I was just going to take a moment to recognize that when we're talking about the UNCITRAL rules, these are by the UN, which is, of course, in everybody's news feed today. But it's the United Nations Commission on International Trade Law. And so they are very well recognized. I think that a decade ago, they were the most prevalent. The London one, the LCIA, is coming up. There's another set out of Singapore that I'm seeing more often. And I think, pros and cons to each of them. As international commerce evolves. But when we talk about the UNCITRAL, that's what we're talking about here. I think that this clause is better, obviously, than the one that you have before, in large part because you do come back to the UNCITRAL provisions, as well as setting out where you're going to be. For me, and I alluded to this earlier, there's three critical things that you want to make sure that your clause addresses. And so the first one, under the arbitration provision, is to set out what your framework is for this arbitration. So that's either LCIA, UNCITRAL, or other. And then the second one that you want to set out is where you're going to be having this arbitration, because that's another thing that you could potentially be disputing, is where one party's headquartered, the other, where the contract was signed, where the project was done. So just pick a place, and that's your place. I will say that I noticed that Vancouver is a very popular choice with international parties, and I'm always happy to go to Vancouver, back where I started my career. But anyhow, it can be anywhere you want. If the parties are saying London, England, you might want to really think about whether that's going to be effective and efficient for your business. And then the third one that you want to consider is, what substantive law are you going to be considering in your arbitration wherever it's going to be held? And these are three distinct things. And I think sometimes we probably all remember conflicts of law class from third year law school, but then we don't necessarily remember how prevalent it can be. And you want to make sure that you specify in your contract, probably does, even absent an arbitration provision, what law is going to govern the contract. But they are two separate and distinct things where you're having your arbitration and what substantive law is going to govern. But of course, if you don't set out your governing law, then it's going to be the law of the place where you're hearing the forum. So you do want to be careful with those three items and make sure that they're taken care of so that we can avoid the situation that Justice Cote spoke of.
Thanks. And if we look over then at the last clause that we have modeled for you, which is what we call the multi-step clause, and we'll put that one up on the slides. And I just ask Sarah to lead off on this one. And of course, remember we talked earlier, folks, about these step resolution mechanisms. So negotiation, mediation, and arbitration. This is a sample of what a clause like that would look like. And Sarah, what are your comments or observations on this one?
Yeah, so I think what the most important thing is when you're looking at these stepped clauses is you want to make sure it's clear in terms of the timing of the negotiation part before it transfers to the arbitration. You want to avoid a circumstance where you're going to get stuck in this never-ending negotiation. You can't move on to arbitration, and negotiation isn't really moving anywhere. So when I speak of that, I'm kind of saying avoid these normative statements such as you have to negotiate in good faith, or parties are going to make their best efforts. You want a specific timeline in terms of how long the negotiation is going to last, and this clause does have that as a matter of blank days. And I just think it's another one of these Justice Cote remarks is you don't want to be in court fighting over, well, is the negotiation over? Have they put their best efforts in? Did they negotiate in good faith? Et cetera, et cetera. So I think when we're looking at these clauses, that's kind of the most important point I would see. And also echoing that is you don't want to be stuck and then potentially miss your limitations period in terms of commencing a claim. So that's why it's especially important to avoid these normative statements.
Yeah, I totally agree. And I've seen that happen, right? I've seen scenarios where you're facing resistance from an opposing party to moving on to your arbitration phase because the allegation is that you have not negotiated in good faith, for example. Good luck. You're looking at a 2-year piece of litigation to figure that out. That's right on the CAPA quote from Justice Cote. And Chelsea or Janelle, any other comments from you or observations on the multi-step clause we've sampled here?
I think that the stepped procedure, like if you explain the whole process, is really valuable. We talked about that at the beginning, and we're kind of tying the two concepts together here. So if you talk about the steps, we have a dispute, we acknowledge there's a dispute. How are we raising that internally? How are we raising that again? Whatever that looks like internally. And then, okay, we can't do that. We now have something that needs to go through arbitration. This is our framework. You've got the whole path. And that just means less to argue about when you've already got substantive project-based things to argue about. So I think that's all wonderful. As far as putting in mandatory mediation, again, I'm conflicted on that. I think it really depends. But even if it's not listed in there, it doesn't mean that you can't go and have one. And like I say, I've had success with great mediators. I've had great success not having a mediator there, but sometimes it's just having the other party in front of, especially if you've got a really great witness on your side, having them explain the evidence. And I'll often take someone aside and say, this is going to be the case that we're going to run, and I'm giving you the opportunity to understand it now before we get further down the road. So thank you, Mike.
Yeah, it makes perfect sense. Those stepped resolution clauses, they were really vogue for a long time, but I think in experience, unless they're very carefully drafted, they can create significant problems. So I think that the comments that Sarah has made and the comments by Chelsea are very apt in that scenario. Certainly that would bear out in my experience. What we've given to you, everyone, is a what we call a lengthy and comprehensive clause. Now, it's not here because it would fill several slides. It's a very long kind of Cadillac clause, and it's not necessarily provided because that's the one you would want to use in any particular scenario, but it's to show you one that attempts to cover everything off. And that's going to be available to you through a link that will be distributed you can take a look at that comprehensive clause, and I'm sure you will find some of it interesting, I hope. It addresses, I think, the pitfalls that we've been identifying in drafting, which relate to very practical matters and some legal matters that, including relating to jurisdiction, that are important that you keep your eye on as you're deciding on these processes and you're doing the drafting of the clauses themselves. We have a few minutes just to talk a little bit about the overview of the considerations, and maybe just to make some final remarks before our last 3 minutes run out. So I'll throw it out to the panel for any final comments or reiterations of what they think are some of the most important points to take away from today.
Yeah, thanks, Mike. One thing I'd like to highlight that we haven't touched on in a direct way so far is, providing for what happens to the rest of your contract while you're in the middle of a dispute. And so often parties may think that, well, if we're disputing, then, the agreement kind of comes to a standstill while we sort it out. But that's really not the case unless the parties expressly provide for it. So I think it's something that is just worth spending some time thinking about and addressing. So, for example, sometimes the response is, well, we'll just provide that the arbitrator has to decide really quickly. We'll give them 30 days, but that's not actually binding on the arbitrator. You're going to go through your procedure. You're going to get the decision that you get when you get it. And in the absence of otherwise having contemplated in the agreement what happens, then you can find yourself at a standstill where parties are continuing to have to spend time and money to, for example, chase regulatory approvals or continue to perform services under the agreement while in the background there's this dispute going on. So, spend some time to think about it. There's no, answer about what should or shouldn't in any given situation be suspended, but it may be that, everything gets suspended, a few things do, but it's really important that other obligations continue. And just something that I think is worth adding to the conversation.
Thanks, Janelle. Great point. So we got about a minute left. Any final comments or observations from our panel on the points before we sign off?
I think your selection of your mediation or your arbitrator is really critical, especially if it's a mediator. You need to find someone that the parties trust. I think trust is more important than likability, because you're asking them to be bound by something that they're not bound by. When it comes to arbitration, a lot of times, it'll say, I'll pick one, you pick one, and then those two arbitrators will pick one. And then one thing to watch when we're talking about limitation dates, if you're getting into settlement negotiations, it's usually a good idea, I think, to have a tolling agreement in place as opposed to something that's less formal, that says, okay, well, we'll agree about this. And just to highlight a point that Sarah made in passing about the enforceability of a judgment, certainly if you're looking at a mediation where a party will tender assets immediately or make good on that debt, that's really worth a lot right now in the COVID world. And I think that all of these things are factors. It definitely has to be a very complex analysis about what your best case scenario. We talk about BAFTA and your best alternative to a negotiated agreement. So all of it factors in. And just want to thank again everybody at Stikeman's for putting this on today. It was a little bit daunting to do online for me and maybe not for you, but you guys did a great job, and really thank you so much from everybody at the ACC.
Yeah, and thanks to you, Chelsea, and all the ACC members. We love working with you guys, and we look forward to doing it again soon. And I wanted to extend a real thank you to Sarah and Janelle as well, who did a lot of work putting these materials together. It was a great job, and it was a pleasure presenting with you today. So everyone, thanks for joining us. Take care, be well, and we'll see you next time, hopefully in person over lunch. Take care.